Hello friends, welcome to Choose Narendra Eyes. Today we will discuss Indian polity. In, of this topic is named Government of NCT Delhi Amendment Act 2021. So first of all we should know why NEES. Then the Government of National Capital Territory GNCT of Delhi Amendment Act 2021. इस एक्ट के थ्रू क्या है जो प्राइमरी जो प्राइमेसी है लेफ्टिनेंट गवर्नर को दे दी गई है ओवर द इलेक्टेड गवर्नमेंट के सिटी में। अब कॉमन फोर्स में आई है। तो अब इसके जानेंगे कि पॉइंट्स क्या हैं। इसके की पॉइंट्स ये हैं द प्रोविज़न ऑफ द GNCT ऑफ दिल्ली अमेंडमेंट एक्ट आर एज फॉल। इसमें अमेंडमेंट किया गया है सेक्शन 24, सेक्शन 24, 1, 33 एंड 44 ऑफ द 91 अमेंडमेंट एक्ट। State that government in the national capital territory of Delhi meant the elective governor of Delhi। इसका मतलब ये है कि जो भी गवर्नमेंट दिल्ली नेशनल कैपिटल टेरिटरी में नियुक्त की गई है वो सीधी सीधी लेफ्टिनेंट गवर्नर की सरकार है। इट गिव्स द डिस्क्रिशनरी पावर टू द LG। इसमें डायरेक्टली जो पावर है वो LG को दे दी गई है। एंड इवन मैटर्स वेयर द लेजिस्लेटिव असेंबली ऑफ दिल्ली इज एम्पावर्ड टू मेक लॉस वॉज and it seeks to ensure that LG is necessarily granted to opportunity to give her or his opinion before any decision taken by the council ministry or the cabinet is implemented. It bars the assembly or its committee from making rules to take up matters council day-to-day administration or to conduct inquiries in relation to administrative decision। अब बात की जाएगी इसकी क्रिटिसाइज क्या है। क्रिटिसाइज कुछ इस प्रकार है। द लेटेस्ट अमेंडमेंट विल ग्रेटली रिड्यूस द एफिशिएंसी एंड टाइमलेसनेस ऑफ द दिल्ली गवर्नमेंट by making it imperative for it hold consultation with LG even when a situation demand urgent action। Significantly, the LG is not obliged to give his opinion to the state government within a time frame। Critics argue that the LG could politically exploit this unbridled power to hamper the government administrative work, and this turn the political tides against the incumbent if he shows desire। It is against the spirit of the federalism। अब हम देखेंगे यूनियन गवर्नमेंट स्टैंड कैसी है। It is in keeping with Supreme Court July 2018 ruling on the eminent powers of the LG and the Delhi government. Following several headliner, the controversies between two, the purported of fair object of the act, including enhancing public accountability and easing out technical ambiguities related to everyday administration। This will increase administrative efficiency of Delhi and will ensure better relationship between the executive and legislature। हम बात करेंगे इसके बैकग्राउंड के बारे में। इनैक्टमेंट ऑफ द GNCT एक्ट। द GNCT एक्ट वाज इनैक्टेड इन 1991 टू द सप्लीमेंट प्रोविजन ऑफ द कॉन्स्टिट्यूशन रिलेटेड टू लेजिस्लेटिव असेंबली एंड द काउंसिल ऑफ द मिनिस्टर्स फॉर द नेशनल कैपिटल टेरिटरी ऑफ दिल्ली। It enables to process of an elected government in Delhi। The Supreme Court had in past appreciated the 1991 development, stating the real purpose behind the Constitution 69 Amendment Act 1991 is to stabilize the democratic setup and representative form of government, wherein the majority has right to embody their opinion in laws and policies pertaining the NCT of Delhi, subject to limitation imposed by the Constitution। नाउ अब सबसे पहले हम डिस्कस करेंगे 69 अमेंडमेंट एक्ट ऑफ 1991 ऑफ NCT नेशनल कैपिटल टेरिटरी। इट एडेड टू न्यू आर्टिकल्स 239 AA and 239 AB under which the Union Territory of Delhi has given up special status। Article 239 AA provides that the Union Territory of Delhi be called the National Capital Territory of Delhi and its administrator and shall be known as Lieutenant Governor। It also creates the Legislative Assembly for Delhi, which can make laws on subject under the state list and concurrent list, except on these matters public order, land and police। It provides for Council of Ministry for Delhi, consisting of not more than 10% of the total number of members in the Assembly, Article 239 AV provides that the President may be ordered suspend the operation of any provision of the Article 239 AA or any other provision of any law made by the persons of that article. This provision resembles Article 356 President Rule. The point of the friction. However, over the years, there was friction between the Chief Minister and the Lieutenant Governor over the power sharing. The focal point of this conflict was in that case of the difference between the LG and the Council of Ministers also and matter. The matter was to be referred to the President by the LG for his decision, and pending such as the decision, the LG was empowered to take any action on the matters and has been deemed right. The judgment of the Supreme Court in the Government of NCT of Delhi and Union of India and another 2018 cases, the Supreme Court held that the government was not under the obligation to seek the concurrence of the LG on its decision, and any difference between them and should be resolved keeping in view the constitutional primacy of the representative government and cooperative federalism. Essentially, the Supreme Court judgment made it extremely difficult for the LG to refer such matters to the President. Thank you so much. Please like, share, and subscribe, and comments. Please. Thank you.